Well, thanks to everyone for their comments. So now we'll open it up to questions. And I thought I'd start by asking the panelists themselves if you would like to respond to anything that you all have said to each other.
Actually, I would. And the only person I need to respond to is Adam, since he was the only one who spoke after me. And I want to make one comment and ask one question. The comment is, I think this was a stealth overruling of Swierkiewicz and Leatherman and the other cases that you talked about. I think the court said one thing and did another. It said it wasn't overruling Swierkiewicz, but it did. I think that sooner or later they will explicitly overrule Swierkiewicz, and I think that they will point to the confusion in the lower courts as a reason for doing so. Because the lower courts can't seem to apply Swierkiewicz, so we might as well overrule it. And that, of course, is a good reason to overrule a case, but not when...
Third Circuit already says it's been overruled.
Third Circuit already says it's been overruled. I think they're essentially right. But, I mean, it's good to overrule cases that lower courts can't understand, except when it's the Supreme Court's intervening cases that create the confusion. The question is, what could Iqbal have pled that would not be conclusory, but would give rise to a plausible claim for relief? He alleged that he was singled out for special treatment. He alleged that Ashcroft and Mueller designed, approved, and implemented the plan under which he was singled out.
And he was the principal architect of it.
The principal architect, and he alleged that they did so out of a discriminatory motive. What more could he have alleged?
So that's a great question. Your first point is a great one as well. Let me see if I can respond to those. With respect to Iqbal, often when I present these ideas, I feel like I'm sort of an apologist for the Iqbal decision, and that's not at all my intent here. But I think there are aspects of that complaint that, from a transactional standpoint, are qualitatively different from, say, Form 11, which says very clearly what happened. The defendant drove a car against the plaintiff. The problem with the Iqbal complaint, and this will get a little bit detailed, but they don't, well, first of all, Iqbal substantively constrained Bivens' liability in a very meaningful way. Frankly, it's not enough to be the supervisor or to be aware of unconstitutional discrimination. You have to be individually making discriminatory decisions, is essentially the way they read it, in order to trigger Bivens' liability. And this was the problem. I think it's paragraph 96 of the complaint says something along the lines of Ashcroft and Mueller and 9 others willfully and maliciously agreed to subject Iqbal to these conditions of confinement as a matter on the basis of his race, religion, and national origin. The problem is it's very hard to see what exactly they did, and here's what I mean by that. There's a general background section that says, here are all the official policies. High level, low level, none of which are alleged to have been adopted for invidiously discriminatory reasons. Then we have Iqbal's confinement, and then all of a sudden we have this allegation that, and there was a willful and malicious agreement to make this happen for invidious reasons. All I would want to see would be something to specify what exactly did they willfully and maliciously agree to do. Was it a let's everyone go and only round up Muslims and treat them this way? If it was they did that for invidious reasons, I would say that's enough. If it was they made a personal order that Iqbal be treated this way, and they did it because of his national origin and his religion and his race, I would think that provides an adequate transactional narrative. If it was they created this entire hold until cleared policy, knowing that it was going to have an adverse effect on Arab Muslims, and they did it because of that adverse effect, that would be enough. What's ambiguous is this question of what they actually did, and because respondeat superior doesn't apply, it's much more crucial in a case like that than it is in a case like Swierkiewicz, where there is respondeat superior. Now, again, that's a fine line. I will acknowledge that. But we're obligated to draw that line, because you may be right that in that next case they overrule Swierkiewicz. But where we are now, we have to heed what the court has said, which is don't assume that we've overruled anything. And what I'm trying to suggest is one way that we might draw that line. And again, I'm not necessarily happy we have to do it, but it's better than the alternative of assuming that we're now in a much stricter pleading regime.
I admire Adam for a heroic effort to rescue these decisions from infamy. I don't agree with him, but nonetheless, if the lower courts are going to deal with these decisions. I'd rather have them deal with the way Adam suggests than the way a lot of them already are dealing with them, which is not the way he suggests. I think actually what we are seeing in some courts, some district courts in the Third Circuit, I know this is true, the judges are paying no attention to these decisions. And therefore we have a process of lawlessness cubed. Now what do I mean by that? I mean by that the lower courts for a number of years were paying no attention to Connolly and Gibson. They paid no attention to Leatherman's, and they paid no attention to Swierkiewicz. They continued, some of them, in the Sixth Circuit and the 11th Circuit particularly, to impose heightened pleading decisions, even though they knew they weren't supposed to do that. That's the first stage of lawlessness. The second stage of lawlessness, in my view, is Twombly and Iqbal themselves. I mean, no matter how hard one tries, one can't really argue persuasively that these cases are consistent with the Supreme Court's own prior decisions. You can't find evidence of the level of complaint parsing that you find, particularly in Iqbal, in the Supreme Court's prior decisions. You will not find a general plausibility requirement in the Supreme Court's prior decisions, and you will not find a repudiation of Rule 9b, either in the Supreme Court's prior decisions or in any lower court decision. They rewrote 9b. So that's lawlessness squared. Lawlessness cubed is in those district courts particularly, where the courts are simply saying we're not going to follow this. But of course, in lots of other courts, they are following it or even taking it further, which means that we're back to the situation that we were in under Rule 11 in the decade between 1983 and 1993, and we're back to the situation that we're in with respect to Rule 56. We have a supposedly uniform rule that is radically disuniform, depending upon what part of the country you're litigating in and what type of case you're litigating.
And did you want to respond?
No.
Okay. And I just wanted to add one other comment to what Adam said. Is I think Adam concentrates on this also accepting the facts as true, and I think essentially the courts actually, even though the court says you're supposed to do that, I think essentially the courts aren't accepting the facts as true.
Right. Yeah. And I think that's right. There are different ways to articulate the conclusory versus non-conclusory lines. Sometimes the court's talking about legal conclusions versus factual assertions. I think the court thinks it's accepting all the facts as true. The question is, what's a fact as opposed to a legal conclusion? Now, I actually try to avoid framing it in terms of facts because I think that's a notoriously fuzzy term. I'm sort of embracing, for better or worse, the court's use of the term conclusory. If I could ask a question to you, actually, I'm curious what, and again, this is sort of a very extreme example, but how would they have treated, in the common law, someone who came in and just said, the defendant violated the law in a way that entitles me to relief? I mean, would that have been enough to get to the jury? You talk in your paper about how factual conclusions have to be accepted as true. How would that have been treated as a demur or anything else?
Well, I mean, you'd typically sort of put this in sort of with a form of action, and so there'd be some facts, right? So I guess I don't know how far.
I guess this issue, what is a fact, right? What is something that needed to be accepted as true then? I guess what I'm wondering is, were they struggling with those issues even then?